morning, honorable senators. Thank you so much for this opportunity to present on this topic of fundamental importance. My name is André Schutten. I am a constitutional lawyer, a disability rights advocate, and the Director of Law and Public Policy with ARPA Canada. Bill C-7, if passed, will greatly expand assisted suicide in Canada to those who are not dying. And this is a remarkable change to a law that is not yet 5 years old and has not yet been legislatively reviewed by Parliament. There's just one job for the civil government to do, one reason for it to exist. It is to maintain and enforce laws that provide equal protection for the lives of its citizens so that all citizens can have equal opportunity to flourish. And expanding assisted suicide to those who are not dying undermines this ideal. In the Carter case, both the trial court and the Supreme Court of Canada admit that, and I'm quoting, the risks inherent in permitting physician-assisted death can be identified and very substantially minimized through a carefully designed system imposing stringent limits that are scrupulously monitored and enforced. And even so, this statement, both the trial judge and the Supreme Court justices actually admit implicitly that innocent people could die. The risks are inherent, they say. And though these risks could be minimized, they cannot be eliminated. The trial judge admitted that none of the other legalized systems has achieved perfection when it comes to risk. The trial judge examined much evidence on foreign experiences with legalized assisted suicide and found lack of compliance with safeguards in Oregon, the Netherlands, Belgium, difficulties with the evidence on the impact of vulnerable people in the Netherlands and Oregon, and that people suffering depression slipped through the approval process, if only in, quote, highly isolated cases. Now that's evidence, we have to remember that's evidence, court evidence, findings of fact, that people who should not have been killed were killed, that people who were suffering from depression were euthanized. These patients were sick, and the doctor, instead of treating depression, killed their patient. Now, Section 15 of the Charter protects every individual's right to the equal protection and equal benefit of the law without discrimination. And the equal benefit of the law is not found in having equal access to assisted suicide. If we accept that line of reasoning, then this would also require corresponding obligations on healthcare professionals never to prevent people making that choice. In other words, society or the civil government at the very least would have a duty to not interfere in a suicide attempt. That's clearly wrong-headed. Instead, the equal benefit of the law interest ought to be understood as having equal access to the full protection of human life in law. That's the benefit that is offered by the criminal code, the full and equal protection of every human life, regardless of disability. If Parliament chooses to expand assisted suicide beyond the end-of-life context, the additional risk to those with disabilities lies not in their capacity to make an autonomous decision, but in society's prejudicial reaction to a request for death from an individual with disabilities. The risk is created by our tendency as society to automatically support such a request based on an assumption that the lives of individuals with disabilities are less valuable. Again, if there is one role for the state, it is to protect equally in law the lives of all of its citizens from harm by other people. And where some citizens are more vulnerable, that role of the civil government should be amplified, not minimized. And it is my opinion that C-7 violates Section 15 of the Charter, not because it is not permissive enough, but because C-7 devalues an entire community of Canadians, removing the full and equal protection of their lives from the criminal code. Thank you.
And Mr. Schutten, first of all, given your significant legal expertise and work on this topic, and I note you have a master's in constitutional law from Osgoode Hall, could you please explain to us why, in your view, excluding mental illness as a sole condition for assisted suicide in Bill C-7 would pass constitutional muster? And also, do you believe that special safeguards and the exclusion of MAID for mental illness is important and legally valid? Thank you.
Thank you very much for the question, Senator. I believe that excluding mental illness is a sole condition for receiving MAID, medical assistance in dying, would be constitutional, that it's not unconstitutional to have that exclusion there. And I believe that's true for two reasons. The first one is because we have to properly understand what is the good, the service, the benefit that the criminal code provides. It's not a right to assisted suicide or assisted death. That's not the good that is being given out to or offered through the criminal code. Rather, the good is the equal protection of human life. And then medical assistance in dying is an exception, an exception of exceptions. It's supposed to be very, very narrow because we don't want a society where we give license to many different people to end the lives of their of other human beings. Now, even if you reject that argument, we still know that and order decision leave room for Parliament to not allow for assisted suicide or MAID for people with mental illness because, and I'm looking at the Truchon decisions actually right in front of me here, paragraph 654 and paragraph 659, for example, in both of those paragraphs, the trial judge says repeatedly that it's because of the limitations of the physical condition of the individual that they're unable to complete their own suicide or they're unable to end their own life in a way that doesn't increase their suffering. It's for that reason that the Truchon decision expands assisted suicide or medical aid in dying. And that's true for Miss Taylor, Gloria Taylor from the Carter case. That's true for Kay Carter. That's true for Sue Rodriguez. That's true for Jean Truchon and for Nicole Gladue. It's their physical limitations. That's the reason why medical assistance in dying was made available. So where it's only mental illness, we shouldn't be expanding that, and I don't think a ruling from the Supreme Court of Canada would require that.
Thank you. Yeah, and unfortunately, we've seen that 4,000 Canadians a year die by their own hand by suicide. So, as you've pointed out, in 95% of those people, data has been shown to prove that is as a result of mental illness. Mr. Schutten, I note in your ARPA brief that just came in this morning, your section entitled, "The 90-day waiting period is not what you think." I'm wondering if you could just please explain that contention and the straightforward amendment you are proposing to fix this.
Yes, thank you again. So it's unclear. It's messy. It's muddled in Bill C7 as to when exactly the 90-day waiting period begins. The language of the bill is very ambiguous. Does it start when the doctor first encounters this patient and processes in his or her own mind, oh, I think this patient might be eligible for MAID? Is that when the 90-day process begins? Or is it going to be when the patient first starts musing about medical assistance in dying, whether or not that's perhaps an option for them? Or is it when the patient actually makes a formal request? And I think that because it's so muddled, we need clarification here. We need guidance. I think doctors who are providers of medical assistance in dying need guidance from you, the legislators. And the easiest change would just be to make sure and add a clarification that the 90-day waiting period begins when there's a formal written witness request from the patient for medical assistance in dying, and strongly believe that request has to come from the patient on their own initiative. There's a power imbalance between physicians and patients, and when physicians are leading the conversation, bringing up this as an option for them, that has a profound impact on the patient. We have to allow the patient to bring up this idea themselves.
Thank you.
My question is for, let me just be clear here who I wanted to ask a question of. André, I think the two questions. I'm not as quick as Senator Batters, and I haven't read your brief yet, but I would like to just get a bit of clarification at the beginning. You made an observation about the scope and responsibility of government as you were beginning to speak about the criminal code, and I wonder if you could just repeat that, if you didn't mind, as briefly as you could. And then the second question, which was a more substantial one, is that, as I understand it, your submission comes from a rich faith perspective, which I respect, but also the ARPA also is pretty articulate in its statement about the need for a separation between church and state. So I would benefit from your explanation or description of how one wrestles with this question on secular grounds, recognizing that there are significant moral dimensions to this, but without deference to sort of faith perspectives, which we've heard a good deal about. Could you speak to that and just help me to understand how the degree to which I should embrace your arguments, recognizing that they are moral, but also driven very much by a strength of your and your organization's Christian faith? Thank you.
Well, thank you very much, Senator. I appreciate both comments. So on the scope of government, my opening comment was merely that if there is one very important, maybe even the most important task of the civil government, it is to protect the life of its citizens. I think that's basic, its most basic calling or responsibility. It has many other tasks for sure, but that would be its most basic one. And then tying that to Section 15 of the Charter, where we know that every individual, every citizen has the right to the equal benefit and protection of the law. Then I would say, well, if that's the basic task of the civil government, to protect every human life as best it can through the criminal code, well, then we have to make sure that that's equally done for everyone, regardless of ability or disability. To your second question on the separation of church and state, yes, we would actually agree. So the Reformed Christian tradition that I come out of has wrestled with this question for hundreds of years, for the last 500 years anyway. And we say, yes, the institution of the church has different responsibilities than the institution of the state. There's a separation of the institutions. Doesn't mean that those two institutions can't dialogue, very much like the way Parliament and the Supreme Court dialogue about issues. Well, in an analogous way, the church and the state also can dialogue. But that said, I take this panel, for example. We have a witness from the Muslim community. We have a witness from the progressive Christian community. We have a witness from a more conservative Christian community. And we have a witness from a secular perspective, all four of which all agree that there's considerable public policy reasons out of a common belief that the individual, whether they have disabilities or not, is a person with dignity who needs to be treated with respect and whose life needs to be protected. So I don't think that that's a position that's unique to the Christian faith. I think it's a position that's across the board, and certainly the medical community. I'm not a doctor. I'm a lawyer, but certainly the testimony we've heard from the medical community. There's many doctors who are their objection is not so much, oh, because of this religious commitment I can't do this. I think it's grounded in I need to serve and bless my patient the best way I can. And in this moment, a request for assisted suicide or a request for MAID is not what's best for this patient. And we do that all the time. So if we say, no, that's not respecting the autonomy of the patient, we're not consistent. I don't think anyone who says, well, that doesn't respect the autonomy of the patient, I don't think we're always consistent on that. Because if it was a suicidal teenager who said, I want out, I'm done with this, we wouldn't respect the autonomy of that patient, and for good reason. And I think we just need to see why and apply that equally across the board. I hope that helps, Senator.
It does. Do I have a minute for a follow-up question, Madam Chair?
Yeah, go ahead.
Thanks. It'll be brief. I guess, Mr. Schutten, one of my frustrations, and I mentioned this with respect to witnesses in the panel before you, is the championing of this value perspective on when it's linked to MAID. But I just don't see enough of that presence of that value perspective short of the question of assisted death. Maybe you've come and spoken when the Senate is concerned about poverty and injustice and vulnerability and disability. Maybe I'm wrong, but it strikes me that the concerns for people with disabilities, the people who are vulnerable, are used as leverage, as instrumentally to advance your cause that medical assistance in dying should be rejected. Can you respond to that?
Yeah, I appreciate your honesty, Senator.
And I'd appreciate yours as well on this. Then.
Yes, absolutely. So I would say that and I can only speak for my religious community that I grew up in and still reside in, and the community that I live in and work in is one that has a high value for disability rights across the board. Every summer, speaking personally, I volunteer at a summer camp for men and women with mental disabilities. I'm paired up with 2 men with Down syndrome. I've been doing that for 15 years, and the church community that I'm a part of runs without any civil government money or support out of our own pockets. We run 5 different homes in this province alone for people with exceptional needs and disabilities. The people in my religious community have long provided through diaconal donations Sunday after Sunday for people who are needy, who have financial needs and so on. And so bringing that back to your original question about separation of church and state, while we certainly see a role for the civil government to also provide a social safety net, we put our money where our mouth is, and with our own institution of the church also do that. So we don't just say with our votes and with our voice, oh, civil government do more here, and here. We say we're willing to do it as well ourselves with our own money, with our own hands, with our own time. And I think we're doing the best we can. Perhaps that lends perspective.
I'd also be interested in whether any of you have looked at the situation of those in institutions and most especially those in prisons and the application of MAID to those individuals. Thank you.
Is there any order in which you'd like us to answer, Madam Chair?
Senator Pate, can you please direct your question to a particular person? Because
Great.
otherwise we don't have the time.
That's great. Thank you very much for, let's start with Mr. Schutten and then Mr. King. And then if we have time to proceed with Iman Rafat and Mr. Hayward, Reverend Hayward. Thank you.
Yes, thank you, Senator. I think there's a number of different amendments that we should be added to C7 to improve its safeguards, to again, re-adding the 10-day waiting period. I think if we take that out, it will cost lives. There's evidence before this committee and other places where people have changed their mind during that 10-day waiting period. Without it, those people wouldn't be with us any longer today. I think that we need to give guidance. The legislature, the parliament has to give guidance to MAID providers as to which of the 2 tracks, the fast track or the slow track, a patient should be on. And the way to do that would be to define or give guidance around what makes somebody's death reasonably foreseeable. The Bloc Québécois member at the Justice Committee proposed a 12-month guidance for that at the Justice Committee that was turned down there. There's no reason why this committee couldn't add it. I think that we need more clarity around the 90-day waiting period. That in fact that doesn't start, is not initiated until a written formal request is made that is witnessed. And then also, I think that to your second question, there has been a report from, and I believe it's in the submissions of the Christian Legal Fellowship, so it's not in ours, but Christian Legal Fellowship presented in the previous panel, and in their submissions, they make reference to a report from Corrections Canada, where MAID has been provided in prison, and it's raised all kinds of concerns where people who have been incarcerated are requesting MAID and receiving it, and it's a questionable practice at best, should be investigated, and that report is worthy of review by this committee.
You would see the need for national guidelines or standards to be incorporated, and how would you do that in this legislation?
I think that the provision of, a lot have been said about palliative care. It's one of the big challenges with our federalism arrangement, right? Palliative care being administered by the provinces. This is a criminal law bill for Parliament to pass. But I think that just changing the language in the criminal code that says that it's MAID cannot be provided unless these other supports have been meaningfully offered, made available. I think that guidance right there puts a lot of onus then on MAID assessors, providers, and the rest of the medical system to make sure that those things are available. And I think that that's proper pressure from the Parliament to those who provide this service, air quotes, to make sure that these other services are available, true help and palliative care and so on. I think that would be enough in the criminal code to encourage the provinces to prioritize palliative medicine.